Hello, everybody. Welcome to our webinar today on financial risks in the cannabis marketplace. This is episode 2 in our 4-part Financial Poise Cannabis series. You can read more about financial poise on slide 24 of the PowerPoint. Today, you will be hearing from the panelists, including Zach Coburn, an attorney with the law firm Saul Ewing, Daniel Cohen, an attorney with the law firm Pashman Stein, and Seth Freeman, a crisis and turnaround manager and asset manager with Glass Ratner. I will be serving as your moderator today. I am a cannabis attorney with the cannabis law firm Vicente LLP. I live and work in South Minneapolis. I was instrumental in lobbying for and drafting Minnesota's adult use cannabis legalization law. Today, my colleagues at Vicente and I represent dozens of cannabis entrepreneurs entering the adult use market in Minnesota as licensed cannabis businesses. You can read more about me and our panelists today on slides 19 through 22. Also want to take a moment to thank our co-producer, the National Law Review. You can read more about them here on slide number 3. A bit more of housekeeping before we begin. As this slide number 4 warns you, you are not our clients. We are not your lawyers. What we do here today is for your general education purposes only and not for you to act upon without appropriate advice from someone who isn't us, unless you hire us, of course. Okay, on to our webinar. My first question, and this will be for Zach, and Zach, please feel free to give a little further introduction of yourself before you answer this question. First question is, how does the ongoing federal prohibition of cannabis affect the structuring, enforceability, and pricing of financings, M&A transactions, and other capital markets activity in the cannabis sector?
Thanks, Jason. And that is a slightly loaded question, but I'll give hopefully
Very
give a
loaded.
clear answer. But just a background, my name is Zach Coburn. I'm a partner at Saul Ewing. I'm a corporate and regulatory lawyer by background. I've been focusing predominantly on the cannabis, hemp, and marijuana industries for over a decade. I started my practice when I live in South Florida, first went medical in 2015. I've been fortunate enough to be general counsel to 2 multi-state operators. The first one I helped take public. The second one I helped restructure their legal team and orchestrate the largest merger in the cannabis industry to date. I typically work with any number of clients from the startup phase to the fully mature company, handling any number of corporate or regulatory matters. Now, all that behind you. So kind of the kitchen sink question. So federal illegality doesn't just add friction, it fundamentally reshapes deal structure. Capital in cannabis is typically priced less like traditional corporate risk and more like jurisdictional or regulatory arbitrage risk. That kind of manifests in 3 ways that we typically would see. First, with structuring, transactions are engineered to kind of set a ring fence around plant touching exposure and preserve that optionality if the federal enforcement posture shifts. So you see holding company layers, IP opco splits, management agreements, real estate separation. This is not just for tax or liability reasons, but to actually create assets and cash flow that remain financeable or enforceable if the operations are impaired, especially if operations in one state are impaired. Creating this many layers allows you to have greater enforceability. So when it comes to M&A, this drives asset deals over stock deals, which is an interesting dichotomy because from a regulatory perspective, most states, stock deals flow faster on a regulatory perspective than asset deals. The second one is enforceability, right? And so here, courts have increasingly enforced cannabis contracts, but there is that residual illegality risk. It still shows up, especially in like lender remedies, collateral design. I can remember years ago, we would structure deals to say nothing would go to federal court, it would only ever go to state court. We don't really see that problem as much anymore. Um, Security packages tend to emphasize hard assets. People ask me all the time about getting lending and financing. Yeah, if you've got hard assets, it's easier. Um, so that over non-cannabis collateral. Um, think traditional financing, UCC foreclosure rights. They typically are paired with license transfer contingencies. Lenders, they may rely heavily on equity pledges or guarantees, change of control rights. Um, the question from a lending perspective is not can I sue? It's more what can I do if I win? What do I get? What do I control? And then the third thing I think that you see this prohibition affecting is pricing. It drives a structural kind of scarcity for institutional capital, right? That you would see in any other industry. So, that compresses the investor universe to funds comfortable that with that reputational or banking friction. Now, what does that mean in layman terms? There's not a lot of money, right? It's harder to find the money, and the money you do find is from a smaller pool of people that have much higher requirements to lend. So until we see federal reform maybe normalizing listing, public listing, bankruptcy access, cannabis capital, that's going to remain structurally expensive. I've told people all along, to me, I think the biggest impediment to normalcy is right now the stock exchanges, NASDAQ in New York. The minute those open up to plant touching, you will see the more traditional blue chip funds, investment banks, and actual companies jumping in the space. But until then, the capital markets are still pretty narrow. That's a whole lot to pack into a kitchen sink question.
Yeah, thank you. You know, before I do have a follow-up for Seth, but one thought that occurred to me that may be obvious to all of us, but not for people watching this, Zach, I might just ask you, there's been a lot of talk about potential rescheduling of cannabis at the federal level.
Yeah,
If we move from Schedule 1 to Schedule 3 with cannabis, does that change anything that you just said? Does that alter that landscape at all?
I'm going to give you the typical cannabis lawyer answer. Yes and no. Um,
That's different than it depends. I thought that was coming.
Right, it depends.
Okay, I'll give you the it depends too, right? So, yes and no. Yes, in the sense that I'll do no. No, in the sense that cannabis would still be illegal, right? As a Schedule 3 substance, it's still illegal. Um, the hard reality is if the federal government took anything but a hands-off approach, the only way Schedule 3 works is if there is some kind of policy change behind it. Because if you are at Schedule 3, the reality is the only people that can dispense Schedule 3 drugs are those that have a DEA license. Think Walgreens, CVS, Duane Reade, any other pharmacy. Um, I don't foresee an industry or an environment where hundreds of thousands of dispensaries or grows or manufacturers are going to be able to get a DEA license. Nor do I foresee, I'm almost 100% certain that DEA does not have the infrastructure to actually set up a program to preserve the state licensing and license these operators. So that's the downside. The upside is, and we'll talk about it a little bit more. The obvious and the biggest one is 280E. That goes away. That opens up capital dramatically for operators. You've got operators operating in the 90% effective tax rate. We worked with a number of companies doing their 280E, coming up with opinions to, avoid a 280E issue. But there are many that think that rescheduling will open the floodgates. I don't think it will. I think it will make some financing in financing agencies and banks more comfortable to jump in. Do I think Bank of America and Wells Fargo are going to be jumping in? Probably not. But do I think larger banks than what we're seeing now will be more involved? Absolutely. Could it possibly spur NASDAQ in New York to get off the bench? That to me is the big wild card right now.
Okay, thank you for that. All right, Seth, and I'm going to ask you a question, and then please go ahead and give yourself a longer introduction than I offered earlier. So the follow-up for you is for investors, lenders, what are some of the important due diligence concerns when considering entering a cannabis deal?
Thanks, Jason. So I'm Seth Freeman. I'm based in San Francisco. I'm one of the leaders of our cannabis practice at Glass Radner, and actually have almost 15 years of cannabis from the beginning of what started off as co-ops or even longer in Los Angeles and San Francisco, prior to even medical legalization. And I'm heavily involved in restructuring, turnarounds, receiverships, ABCs, but also because of the nature of the industry, we end up doing quite a lot of forensic accounting and frankly, where did the money go? So types of investigations on behalf of investors. Um, the impact goes back to the fact that many operators um, don't, except maybe in this new cycle, don't have past experience in cannabis. And so it's kind of new. And we also have operators who don't come from a culture of compliance or were, trained executives or have Harvard MBAs. Not that that's required, but but I think for an investor, you really do have to look at the personalities behind a proposed deal. And this goes back to the fact that it has been illegal, and it's much more profitable to in the legacy market to sell drugs than it is to operate a regulated business. So I think that's the first thing. The other is, as Zach mentioned, um, there are these layers of agreements, and it really does take uh, needing to be able to follow those when you're analyzing the deal and understanding the flow of funds. And that, again, is an outcome of the illegality, needing to have these structures. Investors should look closely at management agreements. And then another thing I'd like to share now is valuations. As Zach said, this is an asset-based kind of financing industry. And it's one thing to get a valuation report. It's another to actually think about if you need to take some enforcement action or take over the company, what actually is the monetization value? And that's something that astute asset-based lenders understand. But I don't think most passive investors or even active investors really understand the delta between the valuation report. And then the last thing right now is, again, a function of illegality, is how is the cash managed? Is it going to be in a credit union, in a bank, in a safe in the store or the facility? We've seen a number of situations where cash is not well accounted for, and needing to put all the information together, unfortunately, after something's gone wrong.
Thank you. Okay, Daniel, thank you for your patience. You are welcome to the hot seat. Um, Before I do have an independent question for you, unless you would like to add anything to this, the question that's been posed to Zach and Seth.
Yeah, there's whenever people talk about the rescheduling issue, going from Schedule 1 to Schedule 3, there's a lot of excitement, and people like to talk about it like it's happening immediately because there's an executive order and everybody's excited because it might really shake up the market. But the reality, I think, is that the executive order is, it's a prompt for people to take a look at this issue, and it's a prompt for other parts of government maybe to treat cannabis differently and to do the rescheduling. But the executive order on its own accomplishes very little. And there's no guarantee that it's going to be rescheduled this year or even next year if it gets that kind of political momentum. So I think it's really interesting to talk about what the impacts would be, but it has to be tempered with this understanding that the executive order on its own doesn't accomplish that much. Um, Not to rain on Zach's parade about what it'll accomplish. But it's just one step.
No, that's actually a really good point. And we aren't even close to there. I mean, the hardest issue is we have no timeline, right, to
Yep.
know when this is going to happen. There's no mandated timeline with it. So, you know, the cannabis companies effectively bought a really good stock bump, right? That's what we're talking about now.
Yeah.
Hopefully we're not looking at another year to wait. Um, but I don't think the Attorney General has this on her priority list.
No.
Uh, yes, well, we'll leave that there rather than diving into a political discussion. I do check in occasionally with my boss, Brian Vicente. We've been in touch with the Trump administration on rescheduling, and I say, hey, this is really going to happen, right? He continues to assure me it will. So, but it may be one of those I will believe it when I see it things. Okay, Daniel, same process for you. I'm going to pose a question to you, but then please give us all a more robust introduction of yourself. So, flipping to slide 14. Um, my question for you is, what do cannabis industry lenders have to consider when they take collateral, particularly in something other than real estate?
Yeah. So my name's Daniel. I'm an attorney with the law firm Patchmanstein Walder Hayden. We are headquartered in Hackensack. We've got offices in New York, in Delaware, and most recently in Pennsylvania. Our cannabis group does all kinds of work. We range from regulatory advising to transactional work, financing, asset sales, stock sales. We help minority-owned businesses or diversely owned businesses with their questions, specifically as it regards to their unique status under the regulations. And we handle litigation matters as well for them whenever they have issues, whether it's a creditor trying to collect something or we go up to corporate governance issues, breach of fiduciary duties in regards to companies, all kinds of issues. So full service law firm, if you've got an issue with your cannabis company, chances are I or somebody else at my firm can handle it for you. Um, when it comes to collateral, uh, a lot of investors like to take equity in cannabis companies as a way of getting a return on their investment. But if you're a lender, you might be looking at a secured or potentially unsecured loan to a cannabis business. And then the question is, what do you take to secure your loan? If you're not taking real estate, perhaps because that's already been encumbered or because it's just not something that's in the deal for you or for your business. I've seen clients who are interested in taking as collateral the crop itself. So giving a loan to a cultivator and they take the plant or the seeds or the farm product as the collateral. Under the UCC, it fits squarely in with farm products. So you can get an agricultural lien on the collateral there. You can file it with the Secretary of State using your run-of-the-mill UCC one. And then because you're dealing with something that's perishable, it's a plant, and something that is expectedly going to turn into something else other than a farm product, it'll be classified later as inventory. You have to track the proceeds. So you need to be on top of your debtor. You have to be careful about what you define as your collateral. You have to make sure you use appropriate as after required clauses, which may do a lot of work for you if that's what you're interested in doing. And you have to potentially make sure that your debtor is compliant with New York's and New Jersey's very thorough seed to sale systems where you can track where the plant goes and what it transforms into so that you can have a perfected security interest in your proceeds. And so if you want to be a secured lender, you want to be responsible, you may have to, be active in tracking what your collateral is at any given moment. Or you may have to be careful to file additional UCC ones after intermediate cash is exchanged.
Seth, I have a follow-up question for you, but I'm going to go off script a little bit first, gentlemen, if you don't mind. So I am in the nascent Minnesota licensed cannabis industry here, and this is my first interaction with a adult use market, and a lot of my clients are surprised that the moment they obtained their license, there were not investors knocking on their door to loan them money. Is that a unique situation, or do you run into that in your practices as well? Maybe anyone who wants to jump in. I
That
mean,
is
is this just
very
not, just
common.
investors are not interested in cannabis these days, or what's happening?
No, I think so. In 2015, 2016, you kind of saw this green rush, right? And I can vividly remember where people would be taking on money hand over fist without an operating agreement, without any kind of investment docs, just based on I've got a license in Pennsylvania, I've got a license in Florida, I've got wherever, insert state. Um, I think most people saw over the next, 5 to 6 years, cannabis is hard. It's a hard and expensive industry to be in. Uh, and so, the tax burden created a bigger issue than most people ever gave understanding to. And the federal government not moving slowly, I think most people thought, oh, the feds are going to legalize. Um, and just that hasn't happened. So it's become harder to invest, harder to get your money out. Um, you know, company goes public and their stock price goes down. So it is not in this day and age in this market, it is not uncommon for mom and pop to say, "Oh, I've got a license for a dispensary in New York, in Minneapolis," and to then turn around and go, "But wait a minute, why doesn't anyone want to give me $100,000 to invest in my business? I'm going to make boatloads." Um, it just it doesn't pan that way. And the reality is capital is tight and investors are smart. They don't want to put their money in a market or in an industry, one, I think to Seth's point, where people don't have experience running the business. Would you invest in a restaurant with someone who's never opened a restaurant, right? That's that I know this is going to go completely off script, but that is the downfall of social equity licenses, is that most of the people in social equity markets have no experience operating cannabis industry. Um, and investors have a difficult time investing in operations where the operator is inexperienced and you have a nascent market, say like Minnesota, where the regulators, I mean, I have clients dealing in Minnesota too. The regulators are still figuring out what works. So no, that is a frequent occurrence, that hypothetical.
Yeah, I agree. When a new market opens up, new state opens up, there's a lot of excitement, and especially around a dispensary in an X location in that state. And there is a perception that cannabis businesses make all kinds of money, and it's also kind of fun, especially in a state where it's just now opening up. So I've seen this before. A lot of cash gets tossed towards operators, but then we get into actually operating it in business. And as Zach said, these are tough businesses.
Yeah. Daniel, any thoughts?
Yeah, absolutely. There are significant regulatory hurdles to investing in cannabis, specifically limitations on the number of businesses that you can invest in or the number of businesses that you can issue a loan to. I mean, New Jersey regulations now say that you're not allowed to be an owner 5% or more in more than one cannabis licensee.
Hmm.
So if you want to issue a significant loan, or not a loan, but an investment and take more than 5%, you can only do that once. If you want to invest smaller amounts, take less than 5%, then you can do that with other businesses. But then you have to take a smaller stake in the company and you may be less willing to give a significant amount of money for that return in equity. If you just want to be a lender, existing regulations say you're not allowed to be a financial source to more than seven license applicants or license holders. So a financier who wants to lend money not only has to address all the issues that Zach and Seth have already talked about, and what are they doing with their capital? Capital's tight nowadays, but they also have to pick seven very specific horses to bet on. They can't pick 20 or 30 or however many they may be able to select in another industry. So they have to pick very carefully because they want to get the best return. They want to make sure that if they're lending money, they get a client or a company who's most likely to pay them back to make good on that loan. So there's enormous regulatory hurdles that bottleneck the amount of money that can go into the industry.
Yeah. I'll just say today in Minnesota, our legislature is reconvening, and I know that there will be a piece of legislation offered to allow licensees to sort of uh, opt out of being a social equity applicant, essentially. So our grand experiment with social equity has had its own problems, and especially because they have to be 65% owned by a social equity applicant, and they can't transfer that license for 3 years until anyone except for another person who would qualify for social equity. So
So
you
there's
look at
a
all
bill
these.
right now that would lift that barrier.
There is no bill, but there's a suggestion. I could see that getting some traction, and
I
I think
love that. I have clients that would die for that.
you're not alone. I mean, we were trying to think about which social equity applicant would not opt out at this point, and it will help the legislators, I think, save face a bit because they'll say, well, it's not our decision; it's up to the individual applicant. But I can almost guarantee you that everyone is going to say, we're out, we're out. Just because of the shackles, really, of that social equity designation. Okay, sorry. Getting back to track. Seth, the follow-up question. Chapter 11 bankruptcy, as we all know, is not available to restructure or sell a distressed cannabis business. So what other turnaround or restructuring options are available to cannabis businesses?
Actions in basically in state court. So receiverships are fairly common in when there's a dispute. So that's one area, and receiverships can be moved by landlords who are frustrated with their tenant, uh, by investors, equity investors, or by lenders, and we see that fairly common in California. The other area in terms of and so a cannabis business can be sold within the receivership, and there have been a number of instances in California because you do get a judge's it's a court approved process that the court can impose uh, some timelines on the state of California and other regulatory authorities to make the transfer, to facilitate the transfers. So it's a little bit like a 363 sale in a Chapter 11 case, but um, but it's all done within a state court receivership. The other is through an assignment for benefit of creditors, which is in California, a non-court, there's no filings of any kind in California. In Delaware and other states, you do have to file certain notices with the court, but it's very quiet. And what happens is essentially in an assignment is the board and the shareholders assign all of the assets to the assignee. And it's not uncommon in either a receivership or assignment or an ABC, as we call them, to actually have an operating receivership or ABC, although it's also frequent that the business is getting pretty close to kaput and it becomes basically a controlled liquidation. So those are two areas. There was a ruling by Judge Basin in California that was upheld a second time over the objection of the Chapter 11 trustee on the case basically involved a cannabis business that was no longer in the cannabis business when it filed Chapter 11, and the U.S. trustee objected to it. The argument was, look, Judge, many companies that were committing fraud while they were operating uh, can use Chapter 11. What's the difference between a company that was in the cannabis business but is no longer utilizing Chapter 11? That has not opened the floodgates for using Chapter 11, but everyone was quite excited about that about a year ago.
Hmm. Thank you. Daniel, Zach, any follow-up comments?
Yeah, I think the lack of access to bankruptcy is one of the biggest, we were talking before about why capital doesn't want to get in. I think next to the tax burden, that's
Mhm.
it.
Right.
Um, the enforcement capacity that lenders and not really lenders, but more investors in finding a way to get their investment back. It's been dramatic, right? And so, even in states like California, which have been cannabis friendly states for decades now, right? You can't find a U.S. trustee willing to. In the case that Seth was just talking about, it literally was a company that invested in a cannabis company. The cannabis company was going belly up and selling off its assets and was no longer, so it was invested in a company that was no longer operating as a cannabis company, and that's like the closest we've ever come.
Mhm.
Uh, so yeah, it's that the lack of access to bankruptcy protection. I mean, think about how unfair that is in reality, right? What business, like what entrepreneur would enter into a business venture and start a new company and say, yeah, but I'm willing to foreclose any ability to have, basic, debtor rights. That's what cannabis is operating. It's effectively operating in layman's terms with one hand tied behind its back.
Yeah, you had that, the tax penalties and the difficulties of entrepreneurship just in general. It's it's quite a risk. Daniel, any further comments?
Yeah, I mean, I know you just made a little reference to the tax problems, and we talked earlier about 280E. Some people, some really aggressive attorneys or tax advisors have found, and applies specifically for small businesses under 30 million in gross annual revenue. But there are some methods that people have found to try to resolve the 280E question. Specifically, it's 471C in the tax code, where you can rely on your underlying books and records to account for the cost of your inventory or cost of goods sold. It doesn't solve the problem completely. It's only applicable to certain smaller businesses who have lower revenues, but people are aggressively looking for other options to do this, and it requires a lot of creativity.
We call that the dispensary fix.
Yeah, exactly.
Okay, back to Zach. And give me 1 second here. My question is how do capital formation structures in cannabis, including high interest debt, convertibles, and preferred equity, create distinct financial and fiduciary risks for investors and operators?
So the simple answer is because cash flow is tax impaired, capital is scarce, cannabis structures concentrate the risk um, rather than the risk is concentrated in the wrong manner. What I mean by that is like let's kind of break it down by different investment thoughts, right? So you say high interest senior debt, right? And you see this with like most large multi-state operators. They have a large senior debt holder, hundreds of millions of dollars. The coupons are high, but the real leverage is in the covenants and the remedies. So you've got really tight cash dominion, which means they have to keep certain amounts of cash on hand, mandatory sweeps if you're a lender, change of control triggers that can shift basically effective control to lenders early in a downturn. So for boards, the fiduciary tension emerges when they're trying to preserve that license value, and that conflicts with creditor enforcement timelines. So a creditor wants to start selling licenses to make their money back. Um, so you've got boards of directors that have to navigate that insolvency adjacent duties, the things Seth has to deal with, while regulatory approvals, they kind of gate any restructuring, right? I mean, keep in mind, like Pennsylvania is a good example. You can't sell a license in Pennsylvania. You can change an ownership within an entity, but you can't move the actual asset. So that's one thing. Then you've got convertibles, right? Which, they look like downside protected equity, but in cannabis, they often embed kind of path dependent control shifts. So conversion tied to financing events or valuation resets that can massively dilute founders um, at exactly that moment where the regulatory risk peeks its head out. Um, investors, unlike founders, face the opposite risk, right?
Mhm.
Regulatory or listing barriers, they delay or block the equity outcome, right? As I said before, it's like ultimately you have investors and the stock is never at the value it once was. Um, you know, some people want preferred equity. Sometimes preferred equity is okay. Um, there's various preferences, redemption rights, you know, dilution protection, protected provisions that kind of outrun realistic cash generation. And that again comes back to 280E. And what it basically means is the company can't hold on to as much revenue because they're either paying expenses or paying taxes on the expenses. Um, you know, and then, across all three, the structural mistake is kind of importing that non-cannabis templates into a regime where cash is structurally suppressed, assets are regulatory concessions, right? That's basically all assets end up becoming is the one hard fact fast thing. Unless think of dirt, right? Land. It's a concession. Um, Terms that assume normal refinancing or bankruptcy options, they kind of misprice both the timing and the risk. There's no way to price bankruptcy protection like you would say in a company doing a normal CPG company going out looking for investment. So, it's kind of a hodgepodge of there is no one right way. It's more like depending on the project, depending on the group, depending on the investors, right? Are you a real estate group that's only investing in real estate assets that you're going to go lease to cannabis companies? Or are you an operator going to buy up licenses state by state? So a lot of it depends on what you're doing and how you can structure and how much money you need, right? If you are dependent on getting $10 million and someone's willing to give you $10 million, they're going to define the terms with which you're going to
Mhm.
take them on, whether that's through a high interest senior debt or some kind of convertible debt or some kind of preference. And honestly, we see this in like a cycle, right? Like for a long time, we saw REITs, that was where the investment du jour. And then we saw debt equity, and that was the investment du jour. And now we're in a phase where people want actual asset lending or something to grab onto. So I think the cycle of the industry, guided with the size of the project and the nature of the investment, really will guide the piecemeal of the investment project you're taking on.
Thank you. Daniel, Seth, any additional thoughts?
I would further Zach's comment. You really do have to kind of stratify the size of the deal and what the vision is, because quasi institutional investors or professional investors, they are looking for some scale, and so their concerns are different, and their structuring, how their sophistication of their structuring is greater. There may ultimately be a Canadian holding company in anticipation of going public later on and so forth, versus a more localized business or somebody saying, I intend to have 8 stores in California, for example, and somebody can syndicate that, raise money, find lenders for that. But from the lender's standpoint, you really do have to think through, okay, what happens if I need to enforce my rights? Then what do I do? Do I how I've got to find a different operator for my growing facility, or the other problem is in California at least, local governments are allowed to designate the specific buildings or blocks land use rights for growing cannabis and dispensaries. And basically, if you're going to foreclose, you're going to have to find another operator. And a lot of times, the lease rates for cannabis are much higher than, let's say, a conventional storefront. So if you are the lender and you're or the landlord and you're forced to find a new tenant, and if you had financed your building based on cannabis level lease rates, you're going to be in trouble. So it can cascade badly for investors that don't have sufficient collateral.
Is it for new markets like Minnesota, is it I imagine it's not uncommon for institutional investors to be almost completely invisible and it's all friends and family races. Is that fair to say? Yeah.
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 Okay. Daniel, anything further?
No, the finding a good business is really difficult when you're a lender or an investor. Every deal is different. And, like you said, you do get a lot of friends and family, angel investors who just need to put a little bit of money in or a lot of money in for a business to get up off the ground. Um, so you have to think about everything. And the municipalities can be a challenge too sometimes because, if you're lending to a business who's trying to start up a dispensary, who's in the process of flipping a municipality who doesn't have a dispensary, to one who will have one dispensary, and that's going to be the one you're investing in, you have to get involved a lot and you commit to a long term business in that one location that you've invested a lot in. Not just in building the business, acquiring your inventory, getting the real estate, but also in, getting the municipal approvals and the permits and the licenses that you need to get there. So, yeah, every deal is different and there's a lot of work that goes into it.
Jason, to your question, right? Something to keep in mind, especially institutional investors, they want experienced operators. So, and a state like Minnesota is a really good example. Minnesota doesn't want multi-state operators. They don't necessarily want vertical operators. And for those that don't know, vertical would be, okay, I've got a license to cultivate, and I've got a license to manufacture, and I've got multiple retail licenses. So you control the full food chain. Um, the bigger operators, they want vertical licenses. So investing, if you're a big MSO coming into a state like Minnesota, it's not necessarily as appealing because you can't have as much as you would say in another state that may cost just as much in investment from them to operate. So, for Minnesota, for example, to your point, Jason, most of the license holders are smaller operations, hemp companies that are trying to convert over, or mom and pops that are opening up a dispensary. That's going to be harder to get investment.
Yeah. I mean, so I think a lot of you know that our canopy limits on our cultivation licenses are extremely low. They were drafted that way by our legislators to keep the MSOs out, and I think that's succeeded to a large degree. But the free market's starting to do its thing, and the recent idea is that for a lot of these micro business licensees who are limited to 5,000 square feet of indoor canopy, they're going to start teaming up and just co-locate together and use those sort of economies of scale to try to, I guess, lessen the burden among them. So interesting things are in play. But okay, coming back to you, Seth. What are the ways an investor can participate in the cannabis industry that can mitigate some of the operational and legal risks?
Personally, I think one of the most interesting is to uh, invest in an IP company for branding because of the fact that it's state by state regulation. Each each operator manufacturer in a state um, may want to license a brand, and the brand can be national. And that's very interesting because you're collecting, hypothetically, collecting your licensing fees or your royalties for the name. Now
Mhm.
you've got to be a brand manager, right? The company that owns the brands has to do a good job marketing and promoting the brand, and also monitoring the underlying manufacturers to make sure that they're complying with the specifications of the license. But I think I'm thinking of Chewy and some other brands. That's one way to enter the market. Um, the other is um, I think we're going to see some of the stronger cannabis companies and landlords kind of go back to the beginning and have some form of a REIT so that you can have some diversification in the different cannabis buildings that rather than just having a loan or owning and leasing a single one, but to have a portfolio. So at least if one blows up, you're not in trouble. I think that those are the two areas, and depending on the type of equipment involved, and I would say it wouldn't be processing equipment because that's very expensive to remove and doesn't really yield much. But packages of more easily saleable equipment and leasing them may be another sort of one step removed kind of way to invest in cannabis.
Daniel, any additional thoughts?
Yeah, I agree. I mean, diversification has always been an investor or lender's, it's been one of the core tools in their box for how to protect themselves against risk. Um, and I think that the regulations I referred to earlier, which keep lenders and investors from investing as broadly as they might like, is a challenge for them. So they invest in different companies, certainly more than one if they can. Um, Diversification is always a good thing in that regard. But the regulations may need to they may need to be reevaluated if that's the number one way that we look at protecting from risk.
Zach, how about you? Oh, you're on mute.
Sorry, my dog was barking in the back. I've been a big believer for a long time that I love my clients that are ancillary providers. I love it. I tell them all the time, it's you may not have as high an upside, but your downside risk is much, much
Mhm.
less.
Mhm.
Um, you know, the entry to the barrier to entry when you're an ancillary provider, whether it's, someone who provides a technology, some IP, lighting, some kind of product, um, you have more flexibility, and less tax burden. So I do love the idea of diversification when it comes to that.
Good. All right, Daniel, we're bringing a very niche question to you about your home state. And tell us about whether New Jersey government is interested in helping cannabis businesses find funding.
Yeah, as an alternate source of funding, if you can't find it from a private lender, there are several New Jersey state-run programs to offer grants or loans or other forms of funding to cannabis businesses. Often they're focused on small businesses or minority-owned, diversely owned businesses, but they exist, and New Jersey has been putting them out pretty frequently. In 2023, there was a program for a total of $20 million in funding. They did it again in 2025 for about $5 million. And now there's a new program called the NJ Leaf that's looking to put another $15 million in funding out towards cannabis businesses in this time it's fixed interest loans, either to support an acquisition of real estate or to support working capital. There's a lot of conditions associated with it because the government's trying to achieve, its own goals. For example, one of the requirements for this new NJ Leaf program is that a successful applicant has to create at least one W-2 full-time job for every $65,000 in loan exposure that the government offers you. But it could be a very valuable way to get funding if you have a hard time getting it elsewhere. It's tough. There's a lot of cannabis businesses will be competing for that money, and for the program in 2023, there were a total of 48 awardees for a grant. It's not very many. So it's competitive and there's a limited amount of funding. But New Jersey seems to be consistently offering that because it wants to support the cannabis industry. I think it's exciting.
Well, okay, let's say I'm an applicant for money. How much can I get?
So if you're applying for this new NJ Leaf program, you may be eligible to get fixed assets from a minimum of 100,000 up to 1.5
Oh,
million.
okay, now we're talking.
It's a lot of money, and that would be for fixed assets. Though that would include owner-occupied real estate, large amounts of equipment that you have installed on the premises. If you're looking for working capital, you can get again from a minimum of 100,000 up to 500,000. And that all depends on your need, and there are, of course, verification requirements for some of those things. If you're looking for a working capital loan, then you have to demonstrate that you've been incurring those expenses for at least a year prior to your application. Um, and you'll have to provide, expenses and demonstrate what you're going to use the money for. But up to 500,000 just for working capital, and 1.5 if you're trying to acquire real estate.
Yeah. Yeah, that's real money. I mean, Minnesota has a similar program, but to me, the amount of money you can get is just not enough really to do anything with. Zach, Seth, have you heard of similar programs in other states?
Not that have been successful.
Yeah.
Yeah.
I mean, the
I,
most glaring one was what New York tried a couple of years ago with their fund, which I don't, seems to have gone up in smoke, no pun intended. Um,
I, I wanted to ask Daniel, are these loans structured in a way like SBA loans where the borrower has to allow a lien on their home and sign personal guarantees, or are they more like grants?
There would be personal guarantee. So this new NJ Leaf program does involve personal guarantees. There's a credit check. You have to have a certain debt ratio. There's a lot of other requirements, but yeah, personal guarantees, security, and all of that.
Mhm.
But fixed interest over, favorable financing terms and flexible payment plans. I mean, those are things that are valuable that you may not be able to get from a private investor.
Mhm.
I also assume that there are provisions within those loan programs where if you're too big, you're not
Yes.
eligible.
Mm.
Yeah, you have to be under a certain revenue threshold. Yeah. For um for the NJ Leaf program, your gross annual revenues have to be under 5 million and you can't have more than 250 full-time employees. So you have to be small.
Um, yeah, follow-up question. I just forgot. Oh, SBA loans. Are those generally available to cannabis businesses, or does the federal illegality of cannabis restrict those? Does anyone know?
I'm not aware if any cannabis businesses that have an SBA loan. Um,
Yeah, I mean, that would be
no.
surprising.
So, um, they are, but they aren't, if that makes sense. So they're not eligible for SBA loans. However, there's nothing in the law that says technically they couldn't get them. And then
Mm.
the crazy thing is during COVID, cannabis companies received SBA backed loans.
Right.
So go figure.
Yeah, got it. Okay. Sorry, I'm deleting this thing. Okay, back to Zach. So we've been hinting at 280E. We're going to address it head on now.
Yeah,
Zach, tell me, in what ways does 280E drive hidden tax, cash flow, and transaction risks for investors? And what operators most commonly underestimate when planning financings or exits?
sure. So when thinking about that question, I tried loading in like everything, right? For those that don't know, 280E is a provision in the tax code. I'm going to give the really, really simplified down version. So for true legal wonks watching this, I apologize. For those that don't know, 280E was created in the 1980s because you literally had someone who was being indicted or arrested or on trial for running a drug cartel.
Mhm.
Yet they were paying taxes, and he was claiming deductions from his drug cartel, from his drug operations. And the federal government challenged it, and the tax court said, well, there's nothing that stops it. And Congress said, well, wait a minute. We don't want people benefiting from an illegal operation. So let's create this new provision of tax code, which says if you are profiting from the sale, or essentially, I'm simplifying, but if you're running a business that's based on selling products that fall within the definition of Schedule 1 or Schedule 2 of the Controlled Substances Act, you are not allowed to take regular and necessary deductions or credits. Now, from any business owner, you ask them what's the largest expense to your employees. It's your payroll, right? So what 280E basically says is unless it is directly associated to the cost of goods sold, you can't deduct it, right? So think of it like that. Unless you're a grow, you're pretty much not dispensaries. They're not deducting anything. Most cannabis companies operate in the 80 to 90 effective tax rate. So like we talked before about cannabis companies making money hand over fist. If you make $1 billion in revenue, but you got to pay 850 million in taxes, you're really not as profitable as you think you are. So back to the question, right? 280E, it's not just a tax line item. It's a capital structure detriment, like full stop. Um, to put it in financial terms, it converts EBITDA into basically a poor proxy for debt capacity. It compresses free cash flow precisely when the leverage is the highest, right? Um, how is it a hidden tax? It's this disallowance of ordinary deduction, which elevates the effective tax rates to levels that basically permanently mimic minority interests in the company. Um, Investors that underwrite to like, and I hate that they do this, but EBITDA, like investors that underwrite to its multiples, they often miss that tax distributions often outrank debt service in practice because operators have to stay current with taxing authorities to preserve licenses. So that ends up subordinating lenders economically, even when they are senior legally. All right. So you're a big bank in Canada and you opened up a shelf for $300 million to a big MSO, but that MSO ends up paying hundreds of millions of dollars a year in taxes, right? That's taking away from your ability to get paid back.
Mhm.
Um, Look at transaction risk, right? That was part of the question. When it comes to M&A, right? Purchase price is tied to EBITDA or some factor of that, or revenue multiples. That tends to ignore the buyer's post-closing tax drag. When I'm doing M&A deals, that's a big factor I got to think about or deal with the buyer side is where is the tax burden going to fall as soon as you close that deal? Um, Things like earnouts, they're linked to pre-tax metrics. They tend to misalign incentives under 280E, right? Sale leasebacks, any kind of opco splits. They don't eliminate entity level 280E when you have like these multiple companies um, where plant touching exposure remains. So, there is a lot of transaction risk. You know, as a lawyer, this is not my area, but those in the finance side, they have to price in the tax aspect when it comes to a deal. I've seen too many deals where they don't price the tax burden, and it creates a massive problem. You pay all this money for an entity, and you come out of it on the back end going, wait a minute, the revenue's not the same. Oh crap, I forgot the taxes. Um, and then, to that point is operators underestimate, right? We typically see a few gaps when it comes to underestimation of their taxes. The first one, assuming some kind of future reform that will arrive inside the investment, horizon that you live in. Um, and kind of underwriting for post 280E leverage world, right? What that basically means is kind of being blinded by the idea of 280E is going away, so we'll take the risk. Um, the second one would be kind of under reserving for tax liabilities during your growth phase when, reported profits may be low, but taxable income is really high. The next one would be kind of timing out your exit, right? Sellers plan these processes around peak revenue rather than peak after-tax cash. And what that basically means is I'm going to sell because I made $500 million in revenue last year, as opposed to I'm going to sell because my after-tax cash is $400 million. Um, that kind of miscalculation goes on a lot. Um, there's a disciplined approach that I think accountants and financing agents would do to kind of model this after-tax cash, but that's more strategic. And I think that people lose sight, especially smaller businesses. There's a lot of companies that have been in this for a decade, and they're just at this point, they've got fatigue. They want out, right? They don't realize they may not be able to get out, or this may be the wrong time to get out. Um, you know, all these things, they don't necessarily happen. And, this kind of modeling, and what ends up happening is, you know, effectively companies do this cost benefit analysis by the company, right? We talked earlier a few years ago, companies started filing amended tax returns and then taking positions, and lawyers like me and others found ways to make arguments that said, here's a legal argument that says 280E shouldn't apply to you, right? Well, that's a cost benefit. Companies got to run that, right? And the cost benefit is the benefit of my tax savings. Okay, my 280E tax liability is $10 million. Well, if I don't pay it, that's like a $10 million financing today. Well, if I don't pay it, is the benefit greater than the potential risk of being audited and forced to repay some or all of that down the line, right? Is the $10 million I'm saving today, taking it now, worth the risk of I may have to pay it 5 to 7 years back at 7%, whatever it may be. So there's a lot of that underestimation and a lot of not modeling your accounting correctly, in a nutshell.
Well, thank you. And gentlemen, we are at time. I'll give Seth and Daniel each the final word. Seth, perhaps to you first.
Sure. Well, I think hopefully the viewers of this webinar have a greater appreciation for the extra complexities of this business. It's not like opening a corner shoe store, and it's not like building out a national chain of fast food restaurants. And there's so much more to consider. And even though we all read and see graphs about the growth of the cannabis business across the United States, it's fraught with risk.
And
And
as the industry continues to grow and competition gets fiercer, especially for dispensaries, the prices of their goods to consumers are going to be compressed. They may not be able to maintain profit margins the way that they used to, or they're going to continue to face problems associated with really stiff competition. So it's interesting to see where it'll go. And as far as 280E goes, it's always good advice not to anger the IRS. So get it right,
well, thank you all for your time and your insights today. I appreciate it. And that concludes our webinar. Thank you.
Thank you.
Thanks,
Thank
everybody.
you.